Hi guys, Happy New Year. It's attorney Ashley Goggins here in Florida with your first Free Game Friday of the year. It is our first Free Game Friday of 2024 and I'm so excited. Before we get started with our question for this week, go ahead and share this out. Tag a father or a husband, a neighbor, coworker, anybody that you know that may need this information. Tag them below or share this out. I really appreciate it. And if you have a question that you would like for me to answer right here on Free Game Friday, just go to freegamefriday.com. That's freegamefriday.com and enter your question. And it can be answered right here on Facebook or YouTube. Okay, so we're going to get right into it. The question of today is, if me and my wife live separately, what can I do to make her let me see the children? Well, the number one thing you can do is you could file for divorce if you guys are not going to be together. If you guys are living separately and have established that there is no longer an intact marriage and you guys do not believe that you can reconcile in an efficient time frame such that the only option to move forward with your relationship is to dissolve it, then you're going to have to get a divorce. Because if you guys are still married and you guys are still intact, meaning there's no legal document or a final judgment that dissolves the marriage, then there's nothing that the court can do to intervene in an intact marriage, because no one has filed saying that, hey, irreconcilable differences, marriage counseling or whatever won't save the marriage. We tried, we've attempted, we've been separate for X amount of days, months, years, hopefully not years, but we've been separated and we're not coming back together. We've moved on, we're living separately, we have our own lives, but we have children together. And if you do have children together, it is important to both parties that they make sure that the children or child maintain a relationship with the other parent. This is so important because a lot of times you see that one parent leaves the home and now that parent goes from having 100% access to the children or child to no access, or access when the other parent allows them to have access. So specifically in our jurisdiction, Florida, and in our counties here in the 4th Circuit, Clay, Nassau, and Duval counties, there's a standing order. And the standing order basically lets the parties know what the guidelines are while the case is pending. So whether it be a paternity case, whether it be a divorce case, or any family case for that matter, generally it's going to apply to time-sharing custody cases. It's called a standing family law order. Well, our chief judge has modified the standing order as of last month. The judges see all the time that this is a big issue where you have two spouses, husband and wife, wife, two married people, okay? Have two married people and they are stripped away from their children. And shared parental responsibility is the rights that you get. When you're married, you have equal rights with the wife. Now, for unmarried parents, equal time sharing is the presumption. So they felt like it was important to let the parties know, both parties know 4 things. Number 1, if your parties live separately, the parents must make sure that the other parent, or the parent that has the children, whomever that may be, sees the other parent and maintains contact with the other parent. That is so important because a lot of times you're not going to be able to see or get a time sharing plan or a parenting plan or any type of structure regarding when you get to see your child unless the other party agrees or they're forced to by the court. The second thing, neither party shall conceal the whereabouts of the child or children. So if you move, you let the other party know. If you move, you let the other party know within 5 days of your phone number, your email address, your address, wherever it is that you live. This is if you have a case that is pending in court. You haven't been in front of a judge yet, you've just filed. Those are the guidelines. Don't conceal the whereabouts of the child. Make sure that you give the addresses, the phone numbers, exchange it with the other parent. You also want to make sure that the other parent that is moved out has access to the child or the children. Make sure you are facilitating that relationship, because that's your obligation if you guys have separated. And if you don't, it will be used against you at a final hearing. For sure. And then the last thing is, don't make any disparaging remarks. Don't talk about the other parent with the children. Don't discuss any ill intentions, any ill feelings. Don't do any of that. No animosity should be shown. This is in writing, you all. This is in writing from our chief judge, from our family judges that have put these new factors into the standing family law order. Because these are the things that are important when, like my friend has asked, you guys are living separately. But the only time this standing family law order applies is once you filed a case. That is why it is to no benefit if you do not believe that the marriage will be repaired, reconciled, that you just linger around and just wait on time to pass by, time that you can't get back with your children. So you need to make a decision. You need to file your case. You can have a temporary hearing. This standing family law order will be put into place, and then you can move forward with your life, both with your life and move forward and bond, have meaningful contact with your children. So that's your answer. I'll see you guys next week. Happy Friday. Have a safe weekend.